Hello everyone, and welcome to our lecture recording for chapter 19. As I said previously, we have skipped chapters 17 and 18, so we have covered every chapter from chapter 1 to chapter 16, but then we skipped 17 and 18, which are basically on consumer law, and I highly recommend that you have a look at these chapters, but as I said, they are not part of your assessments, and that includes of course the final exam. So we start again from chapter 19. This is another part of the textbook which is on business organizations. You will get a whole course on business organizations later on, so we don't really have to go through much detail on business organizations. You're going to have a second year course 2106, Law 2106, which is dedicated to this topic. So today we're going to just touch base on the law of agency. So we're going to cover only this chapter from this part. As usual, we'll start with the chapter learning objectives, which are on page 414 for this chapter. And the first learning objective asks us to explain an agency relationship and distinguish this relationship from others and classify the extent of an agent's authority. The starting point is on top of page 515. If you look at the first paragraph, drop to the last sentence in that paragraph, and it says agency is thus an exception to the rule of the doctrine of privity of contract. So we looked at the doctrine of privity of contract in the previous lecture recording, and we said that there are exceptions to this doctrine, some of which come from common law or from statute or from equity, but there's also a whole body of law called agency law that constitutes an exception to this doctrine of privity of contract, and that's the topic that we will focus on today. So note that this is basically a mixture. This agency law is a mixture of contract and tort law, and our first learning objective starts from the introduction to agency and the idea that agency is a contract that's created between the principal and his or her agent. Okay, and this contract can be relied on against or by third parties. The contract between the principal and the agent could be used against third parties that are not actually part of this contract. That's why it's an exception. This agency law is an exception to the doctrine of privity of contract. Or this contract between the principal and the agent could be used by third parties against them. Okay, so these are third parties that had dealings with the agent for the principal. Okay, so we'll unpack it a bit more in the following slides. So this is your diagram of an agency relationship that you can find as well on page 515. So there are three parties to this relationship. It's a tripartite. So we have a principal, an agent, and a third party that we refer to as a TP, third party. So the principal and the agent are going to create an authority. This is a contract between the principal and the agent. And the agent then, based on this authority, and as we'll see, it arises in different or through different means, but once it arises, the agent then deals with third parties, and this dealing with third parties under certain circumstances will create a binding contract between that third party and the principal. The agent, through their dealings with this third party, are going to create another contract between the third party and the principal. Okay. Now, one example of this agency relationship is an employer-employee relationship. So here we're going to distinguish really this agency relationship from other relationships, and you can see that discussed in brief on page 416. So it says employer-employee. The employee is subject to the control and direction of the employer. Okay, an employee is often, not always, often an agent of their employer. Then you have also the employer and independent contractor, where that contractor is not usually an agent of the employer. And then the principal agent relationship that we have just talked about. Look at the employer-employee discussion on page 416, drop to the second paragraph, and the first sentence reads, as a general rule. As a general rule, an employee does not have the authority to affect an employer's legal relations with third parties because there is no direct involvement with them, i.e., the employee has no direct involvement with these third parties. However, if the employer expressly or impliedly, so through conduct, directs the employee to affect the employer's legal relations with third parties, so your employer tells you that you will affect these relationships with third parties, so you are interacting with third parties, then an agency situation will arise. And you'll give an example. A shop manager may be authorized to buy merchandise for the shop, or a commercial traveler is authorized to sell his or her employer's products. It continues, it is the essence of agency that it should be within the scope of the employment, i.e. contract, that the employee brings the employer into a legal relationship with a third party. So remember then that the general rule on employer-employee relationships is that it will not create any agency relationship. However, there's the exception where the contract of employment stipulates, so the job description basically stipulates for the fact that the employee is going to represent their employer in dealings with third parties. All right. We talked about the distinction between employer and employee and employer and independent contractor. You can see that when an independent contractor is employed, there is no agency relationship that would arise from dealings between the independent contractor and the third party. Okay, so as it says on page 517, you can also link this discussion back to chapter 14 and on page 935, this idea of the control test. So it reads there, employer independent contractor, rather than use an employee to accomplish a desired end result, an employer may describe what they want and then contract with another party called an independent contractor to perform the agreed task for an agreed price. The key point here is that the employee is controlled by the employer, so they don't just tell them what to do but also how to do it. While if you employ an independent contractor, they are not really an employee in that sense, because although you are going to tell them what to do, you don't tell them how to do it. So they represent themselves as the experts on how what you needs to be done, and hence it's their liability on how that thing is going to be executed, what you want from them basically to do. So it says on page 417, the finished task must meet certain requirements specified by the employer, but the contractor and not the employer controls the manner, methods, and materials that are to be used to complete the task. So, when a contractor deals with third parties, it is usually as principal. They are not representing their employer. However, an agent can be an independent contractor, as in the case of an auctioneer. So sometimes an independent contractor could definitely be an agent, and an example of that is the auctioneer, which we will look at also in some more detail very soon. Please look at the business tip below on page 517. It says employers will not normally be liable for the tortious acts of independent contractors. So if your contractor commits a tort, like negligence for example, you wouldn't be responsible for them. In the case of employees acting as agents, the employer is liable to pay either damages at common law or compensation under the relevant state Workers' Compensation Act, where the employee or agent is injured in the course of their employment. Moreover, let's say, if the employee or agent injures a third party in the course of their employment, the employer may be vicariously liable for the employer's tortious act. You can go back to chapter 6 and look at torts generally and the idea of vicarious liability that accrues or would impose liability on the employer even though they are not at fault, but because of this relationship between them and the employee, and given the employee or provided the employee were acting within their job description, then that would attract liability to the employer as well. Alright. Now there are classes of agents, and this is given to you in brief on page 517. So you see that there are special or limited agents. So the agent here, A for agent can only make a particular type of contract or carry out a particular transaction on behalf of P. Here P represents the principal and not the plaintiff. Okay, so the agent is A and the principal is P. So here it is just a particular type of contract. That's why it's special or limited agency. There is also general agency or general agents. Here the agent can make contracts of a class that are normal for this type of agency. For example, they are a manager of a shop, or do some act for the principal that is part of the agent's ordinary course of business. There's also a class called a universal agent. So here the agent can do almost anything that the principal can do, and as you'll find on page 518, this would require something called power of attorney. So there needs to be a deed basically to give this power to the agent, and it might need to be also registered. Okay. Alright. Let's then move on to our second learning objective, and it says discuss the methods of appointment and sources of authority of an agent. As you can see here, the appointment of agents can go through either express appointment, which could be either oral, written, or through a deed, or by implication or conduct. So here the agent, a reasonable person examining the conduct and actions of the parties, would conclude that there is an agency in existence. So again, an objective test based on the reasonable person. Or there could be an agency, an appointment through operation of law, so through either cohabitation or necessity. So under cohabitation, there's a presumption that spouse or de facto has the authority to pledge credit for necessaries suitable for their lifestyle. Or in terms of necessity, there must be a genuine emergency and the agent cannot contact the principal. So here the agent is entrusted with the principal's property. The agent is acting bona fide, i.e. in good faith, in P's best interests. And you will find a case explaining what that basically means, which is the Swaffield, the Great Northern Railway and Swaffield case, a very old case actually from the 19th century, but it's a good explanation of what we mean by this necessity. Then you have ratification, one other method of appointment of agents, where the agent has acted without the principal's authority, but nevertheless appeared to act on behalf of the principal. So here the principal may subsequently ratify the transaction. That's what we mean by ratification. And ratification is retrospective, so it looks at the past and dates back to the time the contract was made. Another case to explain this point is Lambert, Bolton Partners, and Lambert on page 520. Let's then move on to look at the authority of agents. You can link this as well to discussion on partnership on page 584. But in brief, there are three different types of authority. It could be actual or express. This is the easiest to understand. But there could also be apparent authority, where the words or conduct of the principal leads a third party to reasonably believe that the agent has authority, but the agent does not have that authority. So it's reasonable for a third party, looking at what the principal is doing from their words and conduct, it's reasonable for them, based on the reasonable person test, to look at this and say, oh, this agent has authority to do what they are doing, basically dealing with me and entering to this contract with me on behalf of their principal, even though in reality the agent does not have that authority. Okay, so it's a form of really sort of almost misleading the third party to believe that the agent actually has this apparent authority. Okay, but because of that, we enforce this apparent authority on the principal, even though the agent doesn't have that authority. But because of their words or conduct, we hold the principal accountable for any dealings between the agent and third parties in protection of third party rights. So we're saying there's apparent, sometimes also called ostensible authority, but it's the same idea that we're going to enforce this authority, this agency relationship between you, because it was reasonable for the third party to come to the conclusion that actually the agent has this authority. Then there's implied authority, and this would be inferred from the conduct of the parties. So just like implication generally, this is about implying that there's an authority from the principal to the agent because of the conduct of the parties. So the agent can do anything that is incidental to or necessary for the carrying out of the actual authority. Alright, so I'll leave it to you to go through these in some more detail, and we're gonna move straight up to page 525 and look at describing the rights, duties, and liabilities of both the agent and the principal. So let's start with duties of agent to principal. So you have 8 of these, okay, and they are listed for you in the in brief box again on page 525, and it says that the first one, duties of agent to principal, arise from contractual relationship and the fiduciary relationship between the two. So remember that we said that agency law is really a mixture of contract law and tort law, okay, but there's also a component of trust or even equity law that comes into this relationship, and that's what we mean here by fiduciary relationship. It's a special type of relationship that requires a high standard of conduct, and it comes from the word fiducia or trust. So there's a high level of trust, or the expectation of a high level of trust, that will come into existence on the creation of this relationship between the agent and the principal. Okay, so this is where these then 8 duties come from. So you can see here that it's expected that the agent is going to follow the principal's instructions, acting personally. So here it says delegation isn't possible where a personal confidence or skill is required unless the principal gives express consent. So if you recall, we talked about this in the idea of non-delegable duty of care when we looked at, for example, negligence and applications of negligence. Something similar here because of this high level of fiduciary, the fiduciary content of this relationship. You have to actually act in person. Exercising due care and skill, acting in good faith. Okay, so this is of course a very large area when you talk about acting in good faith, but for our purposes is that it simply echoes this dimension of trust that needs to exist between the agent and the principal. So basically this means that the agent must act in the principal's interests. So if you look at page 527, it says an agent is under duty to act in the principal's interests. This duty arises from the fact that an agent stands in a fiduciary relationship with the principal. Therefore, the agent must act in such a way that there won't be a conflict of interest with the duty. There's also maintaining confidentiality of information and keeping separate and proper accounts of all their dealings with third parties, not making a secret profit, and again this is something that flows through from this idea of fiduciary relationship, and not receiving secret commissions. Alright. Now there are also rights, so we've just covered these sort of duties of the agent to the principal, but the agent also has rights that they can enforce against the principal. And that discussion takes us to page 530, and again you have an in brief box summarizing these rights. Typically we talk about 4 of these. So right to payment, right to indemnity and reimbursement. So here A is entitled to be indemnified against any liability and reimbursed, so paid back for any expenses while carrying out the principal's instructions. Right of lien. So we haven't talked much about lien. We will probably broach the subject in some more detail when we look at chapter 23 in relation to some of the economic torts. Okay, but here we'll just say that the agent has a right to retain possession of goods of the principal until reimbursement of expenses and commission, if applicable, until these have been paid. So that's what lien really means. You have the agent has the right to possess the goods or items that belong to the principal, and keep possession of these goods or items until they are paid for their agency, so their expenses and commission. Then there's the right of stoppage in transit, which is related to this line, this right of lien. So if the goods are still in the carrier's possession, so the goods are in transit, if you like, then the agent may be able to resume possession. So before they get to the principal, the agent can stop that delivery and withhold the goods until they are paid their dues in terms of expenses and commission. Alright, then we also have, this is the third sort of part of our third learning objective, and it talks about now liabilities, okay, of the agent and the principal to third parties. Okay, this is now liabilities of both, you know, the principal and the agent, their liability to third parties. So this starts our discussion on page 531, and there's an in brief box there, and it says at the top there, as a general rule, so page 531, the in brief box, as a general rule, an agent cannot sue or be sued on a contract between a principal and a third party where the agent discloses the agency relationship and names the principal, or the agent discloses the agency relationship but does not name the principal. So either way, if the agent discloses that there's a principal, so I come to deal with you, I want to sell you my pen, or I want to sell you a pen for $10, and now I'm telling you this pen is not my pen. I'm selling it for my boss, or I'm selling it for someone else. So I'm telling you that I'm selling this as an agent. I'm selling it for someone else. If I explain that to you at the beginning of our dealings of negotiations towards achieving this contract, then the point is again, the agent, myself, selling you this pen, I cannot be sued on the contract, because now the contract is going to be not between you and me, it's going to be between you and the owner of this pen, the my boss, for example. So the contract for selling the pen and the payment of $10 now is between you and them, not with me. Okay. However, if the agent doesn't disclose the agency relationship or name the principal, A will be personally liable on the contract. So if I come to you and say I want to sell you this pen, and I don't actually explain to you whose pen this is, and I give you the impression that it's my pen, I'm selling you my pen, then I would be held personally liable on this contract. Similarly, the agent will be liable for breach of warranty of authority if they exceed the authority, express or implied, given to them by the principal. So if you drop down again on page 431 under disclosure of an agency relationship and naming of the principal, it says, as a general rule, where the agent contracts for a named principal, so they name the principal, the agent is completely discharged from the agreement and cannot incur either rights or liabilities. So discharged means that they discharge their rights and liabilities completely. So a privative contract exists between the principal and the third party. Here there would be this third party privative contract between the principal and third party. Okay. We said that the agency relationship is an exception to this doctrine of privative contract because it brings in the third party into this equation, but we didn't say that there would definitely still be privative contract once there's a contract between the principal and the third party. Okay, and then we talked about where an agent will incur liability. So if they have executed a deed in their own name, or because of usage or custom, or because the principal is non-existent, or because they agree to be liable, or they are in breach of a warranty of authority. Again, risk management alert at the bottom. An agent must disclose an agency relationship to avoid liability. Every time then we're going to deal with someone, if it's not your stuff you're selling, it's very important to explain from the very beginning that you are actually acting for someone else. Okay. Let's look at page 532. Again, it says where the agent does not disclose the existence of a principal. So if the agent contracts in their own name and conceals the existence of the agency relationship, then the third party would not know of the existence of the principal because the contract will have only the agent's name on it. If a dispute arises, then the third party has the option of suing either the agent, or if they discover who the principal is, then they can also sue the principal. So this is what we call the doctrine of undisclosed principal. Then there is the breach of warranty, talking about the idea of this risk management alert on page 532. Only a third party can sue an agent for damages where there's a breach of warranty of authority. Okay, we'll leave that there then and move on to the fourth learning objective, which asks us to identify various means for termination of an agency agreement and identifying remedies of a principal for breach by an agent. So this starts, there's just a little bit that I want to also highlight, which is the liability of principal and agent in tort. So it says the principal will be liable to third parties for any tort committed by an agent if the agent has acted within the scope of their actual or apparent authority or employment. The business tip as well on page 533 says avoiding liability as an agent. If you are an agent, then you must ensure that you act within the scope of your actual or apparent authority if you want to avoid liability both for breach of warranty and any torts that you commit during the dealings with the third parties. Let's look at termination then on page 534. You have a business tip there that says steps to take to avoid liability on termination of the agency agreement. So if the agency is terminated by agreement, the principal is under a duty to notify those third parties with whom the agent may be doing business. Also, drop to the second paragraph, the second line, it says, however, if the principal fails to give proper notice of the termination to a third party, the agent still has apparent authority to bind the principal to a contract with a third party who is not aware of the termination. So it's very important that you make sure that the third parties know that this person doesn't work for you anymore or doesn't represent you anymore. Okay. Now, there could be many ways of termination, so either through mutual agreement or revocation of the agent's authority. Okay. And this could, by the way, could be done at any time by the principal and without the agent's consent. There could be also termination by the agent withdrawing from the agreement or because of secret commission. So an agency may be terminated by the principal where the agent has accepted a secret commission, or completion of a specific purpose or act agency, so one specific agency, or if there's a time limit, or because of operation of the law through performance or lapse of time or even death. Also insanity, bankruptcy, and frustration. We have looked at these in previous recordings, so I'm not gonna label them in much detail. I think you can go through them and go back and look at them in the previous lecture recordings or in the other textbook chapters from previous lecture recordings. I think that they should be self-explanatory by now. Alright. Let's look then at remedies again, and this time I'm going to look at remedies not in contract but remedies of a principal against an agent. The major remedies then are listed on page 536, and it says the major remedies for a principal for breach by an agent include rescission. Okay, so this is not really very accurate terminology because we said rescission is not available for breach of contract. It should actually be termination. So once the agent breaches the agency agreement through, for example, taking secret commission, then it would be open for you as a principal to terminate this contract, or to refuse to pay a commission, or to sue for damages, or suing the agent for recovery of a secret commission, for example. Alright. Let's then list specific types and classes of agency. This is on page 136, the fifth learning objective, and the specific types we're going to look at start from mercantile agents on page 537. There's a risk management alert as well that says an auctioneer. This starts with auctioneers actually on page 536, and it says an auctioneer is an agent of the vendor, but after the fall of the hammer becomes the agent of the purchaser. Remember, the auctioneer is really an independent contractor, but this is one of the situations where you'll find an independent contractor becoming an agent. Look at what it says, drop to the second paragraph. The second line says a lien may be exercised over any property of the principal that's legally in the possession of the auctioneer until remuneration and proper expenses are paid by the principal. Okay. Now remember that there's a different scenario where there is no reserve on the auction. Okay. So what we mean by reserve is reserve on the price at which you are willing to part with this item or goods, i.e. sell them. So it says if the auctioneer makes no mention, okay, about a reserve price, i.e. the minimum price below which the seller, so their principal really, isn't prepared to sell, the law is unclear, okay, as to whether or not the auctioneer has to accept the highest bid. The bidder cannot sue on the contract of sale because there has been no acceptance, but there may be a personal action against the auctioneer. Without reserve then, in the case that the goods or property may be sold to the highest bona fide bidder. Where there is a reserve, on page 537, it says where a reserve price is published, the auctioneer's authority is limited, and so acceptance of a lower price that the reserve won't bind the principal. Okay. So that means that the authority of the auctioneer is limited, and acceptance of a lower price than the reserve won't bind the principal. So if they accept something below this reserve, that is not a valid acceptance. Alright, another type is what we call factor agents. A factor or mercantile agent is an agent who is employed to buy, sell, or other. So again, a factor or mercantile agent is an agent who is employed to buy, sell, or otherwise deal with goods or merchandise on behalf of a principal. So they have possession or control of the goods and so can sell them in their own name. Okay. So here remuneration is usually by way of commission, and sometimes to secure the payment it may be necessary to exercise a lien over the principal's property in the agent's possession. Okay. So any third party here who obtains either the goods or the documents of title from a factor without knowledge of the withdrawal of authority will get also a good title. So because they didn't know that there was a withdrawal of authority by the principal, as we said previously, they would still be protected by the law, i.e. the law will find that they got a good title to the goods that they have obtained. Okay. Now there's also brokers on page 538. Okay. The broker is a general agent, okay, but doesn't have either possession or control of the goods. So that's the distinction between a factor and a broker. So a broker, for example, of shares. Okay. So brokers cannot sell or sue in their own name and have no authority to receive money. They have no authority to receive money. Then you have the fourth type that we call del credere, and these are really agents that will not only ensure that goods will be sold, but for an additional commission they will guarantee that they will be paid for. So this is like an insurance on top of their services, if not by the purchaser then by the agent. So you will pay them more as an insurance to make sure that you will be paid if they are if these items or goods are sold. So you are guaranteed the payment even if the purchaser ends up not paying. That's the third party. Then the agent, this del credere agent, so they will guarantee that you are going to be paid. There are also partners. So partners are the agents of their co-partners, and then there's this matchmaker that we call real estate agents. As it says on page 138, the term really is a misnomer because, strictly speaking, real estate agents are not actually agents because there is no relationship of principal and agent. So it says, as a general rule, the real estate agent is merely authorized to find a purchaser and is not given authority, either actual or apparent, to enter into a binding contract on behalf of the vendor. There are other classes as well that we're not going to really dwell on. So you'll find on page 538 at the bottom says other types of general agent include sub-agents, company directors, shipmasters, married women, commission agents, bankers, and travel agents. Alright, so then that brings us to the end of this lecture recording for chapter 19. The next lecture recording is going to take us to chapter 23, and chapter 23 is going to be the first chapter that we will look at online. So we're going to really cover 3 chapters that you find online at the Milo Lab website, the Pearson Milo Lab website, and we will start with chapter 23 and then move on to chapters 29 and chapter 30. So all these last 3 chapters are actually online and they are not part of the textbook, the printed textbook that you get from the bookshop. Alright, so we'll leave it there for now and we'll be talking again soon.